Welcome, everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. I'm Senior Staff Attorney Susan Ingalls, and I am here with our IT Director, Pat Muller, who's helping me out in the background as our producer, where Kenneth Elliott is not with us today. So I appreciate Pat being here to help out. Today I'm going to be discussing the Uniform Heirs Property Act in South Carolina. It's known as the Clementa Pinckney Act, after our state senator who was killed in the Emmanuel Church shooting many years ago. And it's something that's really important in states like ours in South Carolina, especially down on the coastal area. There's a really high impact on African American families, and so that's one of the reasons that now during Black History Month we wanted to highlight this act and talk about what the pitfalls are and the complications and so forth of having to litigate heirs property under that act and under our South Carolina partition laws, and to show people mainly why it's so much better if you can come to an agreement, but if you can't, this is how you can resolve all the interests of people in a piece of land that is owned by a lot of family members. So we'll be talking about that. Before we get started, we do want you to know that this is not legal advice. It's just general information for the public, and we hope it'll be helpful to you. But if you need the help of a lawyer on this or some other subject, you can call our intake line. That information will be on the last slide of the presentation, so you can find that information there, along with a good list of all of our other resources that you can access on our website and in other places. Also, just as a reminder, we do post recordings of the Level Up Law episodes on our YouTube channel, and so that will be done with this one as well. And as an added bonus on today's episode, everyone who registered for this particular episode will receive by email a flowchart of how the Uniform Heirs Property Act works in a lawsuit, because it is a little bit complicated, or at least confusing, I think, and you'll see that as we go through it today. But if you attended live and registered, you will get an email that contains that flowchart, which I think helps out a lot. So that will be posted hopefully this week. If not, it'll be posted by next week on our YouTube channel, and you just go to the Level Up Law playlist there on our YouTube channel. So that will be where you'll find it. I do want to just also mention that it's so important to us for you to share these broadcasts to people that you know they might be helpful to, and also to, while you're on our YouTube channel, be sure and subscribe there, because we do want you to, as a subscriber, sign up for alerts, so every time we post something on the YouTube channel, whether it's a Level Up Law episode or something else, you'll know it happened and you can go check it out and see if it's going to be helpful to you. So having said all of that, we will get started with the Uniform Heirs Property Act. And again, as I mentioned, it is named to honor Clementa Pinckney, who worked tirelessly in this area before his death. So we're going to be talking about litigating under the Heirs Property Act when the heirs don't agree. Now, there'll be a couple of places where we talk about agreements, and those are so helpful, and really it's the best way to do these, but you can't always get everyone to agree. So this act really outlines how to do a partition when there's heirs property that has those special family considerations. It's in Title 15, Chapter 61, Article 3 of the South Carolina Code, and it's been in effect since January 2017. So any kind of heirs property that is going through litigation will, since January 1st of 2017, will go by this particular act. And so the first thing that any kind of statute like this has is a list of definitions. And this particular statute is no different. There are descriptions of how you define a descendant, an ascendant, and also even a collateral heir when these are mentioned throughout the law. Also, the determination of value, which is a big part of any kind of partition and certainly is a big part of an heirs property action. Also, and this is the most important, is the definition of heirs property. Because sometimes we think that a piece of land is heirs property, but it may not technically qualify under the Act as heirs property. And if that's the case, then a partition of that property has to go just through the normal partition statute. And that's in Article 1 of this particular law. But heirs property has to have certain requirements. And the very first one is where we talk about agreements for the first time. So there has to not be an agreement between the co-tenants, meaning everybody who has an interest in the property. There has to be no agreement. So if you've come to an agreement about everyone's share of the property, then that goes in a totally different direction because it's by agreement. And that's typically going to be in a quiet title action. But also, if one or more of the co-tenants acquired title from a relative, whether that relative is living or dead, okay, and any of the following applies, and there's 3 different things, so it could be any one of these, it doesn't have to be all. So 20% or more of the interests are held by co-tenants who are relatives. So at least 20% of the people have to be related to each other. 20% or more of the interests are held by an individual who acquired title from a relative, whether the relative is living or deceased. And then the other option is just 20% or more of the co-tenants are relatives of some sort. So this is how a piece of property will qualify as heirs property. And that's the first thing that really has to be determined when you're in a lawsuit under this act. But here's some of the other definitions that you'll see. And, you know, I do want to highlight what the manifest prejudice or manifest injury. That's something that we'll talk about later on in the presentation. But it's an important factor when considering partition under this act. Obviously, partition by allotment is going to be splitting up into shares. Partition by sale is going to be just selling the property and paying everyone what their share of that money is. And then partition in kind is when you just divide a piece of property up and give everybody a piece of it according to what their percentage share is. And then finally, I do want to highlight how time is computed in this particular act, because several of the time periods that are involved as the case progresses are just a week long. And so you'll see here that if a period of time is 7 days or less, then you don't count Saturdays, Sundays, and holidays. So you do get that full 7 days. When it says a week, you get a full 7 days, not counting weekends and holidays. So I think that's really important because that's a really short amount of time. Okay, so that's been determined. It is heirs property, so you're going to file the case. first thing that has to happen is the court actually has to determine that it's heirs property. So you may think it's heirs property. You may take the position that it qualifies as heirs property under that statute, but there has to be a court order basically that says so. So the court gets to really make that decision. So you have to present to the court why your property qualifies under that definition that we just went over. So that's one of the first things that the court is going to do is, and one of the first things that you do when you file the lawsuit is you include a motion that says we want the court to have a hearing and make that determination that this is heirs property. And if the court makes that determination, then everything's going to happen under this Article 3. So when you serve the lawsuit, it's going to be the same way that that is normally done. But one of the additional things that is important when it comes to heirs property is it's family property. So lots of times different members of the family might be on the property. And so one of the additional things that you have to do besides serving all the co-tenants, all the possible owners that you've identified with the actual summons and complaint, you also have to post on the property. So the person who actually files the lawsuit as one of the co-tenants has to put a conspicuous sign on the property that gives all the information about the lawsuit. In other words, this lawsuit has been started and this person is the one who's filed it, and these are all the other tenants. If there's a common designation that the property is called by most people, the family, that needs to be put on there as well. And then the court can also determine through its order to also put, as I said, the name of the plaintiff and the name of the getting some feedback. Can you help with that? Pat? I mean, your feedback. You can help with that. Okay, I think we have that cleared up. Okay, I think we got that feedback cleared up now, and so let's move on to the next slide. So there's one way that property can be sold by partition, and that's with a writ, what's called a writ of partition. And this just means that a court appoints some commissioners to make all the decisions about the property. In other words, they have to, of course, they have to be impartial and disinterested commissioners, but they will determine what the shares of everyone is going to be, and also can determine what the value is. But those commissioners can also say that a partition by allotment cannot be fairly and equally made, and that the property should be sold, and that it should be divided according to everyone's share as it's been determined. And boy, determining those shares can be difficult depending on how many people they are. So another reason why you want to try to get an agreement. You might have a very fractional share, like, 1/50th share of a piece of property, depending on how many owners there are. Okay. Now, determining the value of the property, that's really the next major thing after determining that it's heirs property. The court has to determine that value. And again, they can do that under Rule 71 by appointing commissioners and having them determine the value. But also the court itself can then determine the fair market of the value. And one of the ways they do that is by ordering an appraisal. Okay. Now, keep in mind that an appraisal has to be paid for, and that's going to have to be paid for by one or more of the parties to the action, and that's a determination that the court will make eventually if there is an appraisal. Now, the court can also make a determination that that having an appraisal done is maybe too expensive or too costly, and that that the value of the property can be just as well determined by the court hearing testimony and taking evidence. And so the court does have that ability to say, yeah, you know, the cost of getting an appraisal on this property just far outweighs the value that an appraisal would have in this particular situation. So that is definitely something that can be done. Now, here's one of our periods of time of 1 week that's always, I think, in something like this, really important to highlight. So the court would have, if they say, oh, we don't need an appraisal, that's too costly, then the court has that evidentiary hearing and determines the value. And then they send that order where they determine the value, it's a court order, to the plaintiff or the person who filed the action. And then they have to then send that to everyone else within 1 week, 7 days. Now, this is one of the things I think is important to think about if you're the one bringing the Partition of Heirs Property lawsuit, is that you have a lot of responsibility. Every time there's a decision like this, it's going to be your responsibility to notify all the parties. So if you've got, you know, 50 people with an interest, you're going to be sending out those notices to 50 people. So it's important to know that going in, because it can get very labor intensive, and also there's cost involved. Now, if an appraisal is ordered, and this is under the same section of the statute, then the court is the one who appoints the appraiser. And this section says what those qualifications are and how that's to be done. Now, the court is going to have the appraiser file its appraisal with the court. And keep in mind, as a party to the action, this is one of the many places where you have the right to, you know, object to what gets done in the lawsuit. So you might think that this appraiser that's been appointed is not disinterested, and you may have some reason for that. So you can object, raise your objection, and have the court, you know, make a decision on whether or not that's your objection has some merit, and potentially change the appointment. And then once the court receives that appraisal, though, from whoever they end up appointing, then again, the court's going to send it to the plaintiff or the person who filed this case, and they then have to send that notice to everyone else of what the property has been appraised at within 1 week. Now, any party that objects can, you can object, as I mentioned, but you really only have 30 days to object to the appraisal. So that 1 week of sending the appraisal information is important. As soon as you get it, you need to make your objection if you have one. So after the appraisal is filed, as I mentioned, the court's going to then conduct a hearing to determine the value of the property. And keep in mind that the court has the right to, or the ability, the authority to consider other pieces of evidence besides just the appraisal. The court may find that the appraisal is probative of what the property is actually worth, but the court can also take other testimony, other documentary evidence, and so forth that any of the parties want to put forward if they think that the property is more valuable, for example, than what the appraisal says. So, so then the court determines that value, but they still have to consider the merits of the actual partition of the property. The reason for that is property can be partitioned in several different ways. Just like previously, heirs property had to just go under the regular partition action law. Now it goes under this law if it's heirs property, but you still have to determine in what way it should be partitioned, if it should be partitioned at all. And we'll talk about those ways as we go through the rest of this, but it's basically partition by allotment or partition in kind, and then partition by purchase. So we'll talk about all those here in just a moment. But once the court's determined the fair market value, they send that to the plaintiff or the party who filed, and then within 1 week of that, that party has to send copies of the fair market value decision to everybody that's a party to the lawsuit, meaning everyone who has an interest in that property. And again, it mentions here, as I said earlier, the court can decide who's going to pay for that appraisal. For example, if everyone is going to get a significant sum of money out of a sale, for example, the court may say everyone should share in the cost of the appraisal. There may be just 4 or 5 people who have the larger share, and if that's the case, then those people who are going to get the most money out of the sale might need to pay a higher amount of that appraisal cost because of the benefit that it's going to give to them. Okay, now, once this has been determined, any of the co-tenants can say to the court, well, I think this should be partitioned by a sale. I don't think we should give everybody a piece of the land, for example. I think we should just sell it, and everyone gets part of the money according to their ownership percentage, or their what's sometimes called their fractional ownership share. Once that happens, then the court will notify the parties. And the interesting thing is that if you, and this is important to remember, if you request of the court that this be a partition of by sale and nothing else, then you have basically lost your ability to purchase any of the interest in the land. In other words, you're saying, I don't want to purchase anybody else's interest. I want everybody's interest to be sold, and I get my part of that money. And so once you make that call, then you can't go back and do it the other way. So I think that's important to know starting out at this stage of the litigation. So then any co-tenant that wants to purchase the property can then say, okay, but I don't want it to be sold. I want to purchase the property. Well, there may be more than one person who says that, right? And so this act provides for that. So you got 10 days to say, I want to purchase the property. And then anybody that wants to do that can say the same thing. So it may be there's only the one person who wants it to be sold, and everybody get paid their share of the money. And it might be all the other 50 people, for example, that say, no, I want to purchase it. Well, when that happens, then there is a hierarchy of how that's determined. So, and of course, here the statute, it tells you how that is calculated. So, you got that 10 days, right? And after that 10 days is up, we've got to determine, did one co-tenant elect to buy all the interests of everybody? Did more than one co-tenant? Like I said, maybe 50 people want to buy out the other interests. And then 3, it might be nobody wants to buy the interest of everybody else. Maybe everybody does want it to be sold or partitioned in some other way. And so this part of the statute says what's going to happen with each of those eventualities. So if one co-tenant elects, and they have to notify the court, and the court lets the plaintiff who filed this case to begin with know that, and they have to notify everybody else. If more than one co-tenant elects to purchase the interests of everyone else, then the court has to take another step. They've got to allocate the rights of those people. So it might only be 5 people who say, well, I want to buy all the interests. So the court has to, pursuant to the calculation method here, calculate those 5 people's interests and what their purchase price of the remaining shares would be. They get credit for what their share is. They don't have to pay for their own share, but they have to pay for those other shares. And so once the court has determined those fractional interests, then the court's going to send notice to that plaintiff who filed the action to begin with. And once they do that, that plaintiff has 1 week to send everybody that order and let them know who all has chosen to buy shares of the property and what their share is. So that gets sent to everybody within that 7 days. And then if none of the co-tenants say, I want to buy all the interests of the co-tenants that requested partition by sale, that means everybody else wants it to go by sale, then the court is going to notify the plaintiff of that and let everyone know that. And then at that point, the court's going to go ahead with resolving the partition action on the merits. It's like what's going to now happen. And so the court's going to set a date for a hearing. There's a 60-day window there, and that's important because you've got all this information, you've got an appraisal, you've got evidence, whatever, of the value, and this gives you some time to make a determination and sort of prepare your part of the case before there's an actual hearing. Now, if there is going to be a purchase of shares, then here's how that goes. This part of the statute is going to tell you how the price has been set, and the court's going to say everybody's got to pay their money by this date, okay? And that's the date that's, you've got that 60 days to get your money together, basically. And so that date gets set, everybody's supposed to pay their money for their share that they've said, I want to buy my part of the remainder of the shares. Well, then you got the question of, do these people actually pay their money into the court in a timely fashion? And this gives all those eventualities. Now, then no later than 20 days after there's a notice of who has paid their money, then any co-tenant who has paid their money can make an election to pay for that other part. In other words, okay, that person didn't pay their part, but I want that share as well, or my part of that share. And so they can say, yeah, I'll pay some more money to get that part. And then if no one pays their price for those remaining interests, then it goes right back to the court resolving the action in total on the merits. And as I said, if more than one co-tenant pays their share, some, maybe not all, but at least more than one, then the court's going to calculate how much everybody gets. It's a little more than we have time to go into today. Okay. Then, no later than 40 days after the parties get that notice, any co-tenant entitled to buy an interest can request that the court authorize a sale as part of this case of all the interests of the co-tenants that are defendants, but that haven't taken part in the action. Those are called non-appearing defendants, or sometimes we call them defendants who are in default because they didn't answer the complaint and claim their share. They didn't participate in the lawsuit in any way, but they still have a share. So their share doesn't just get eliminated just because they didn't answer the complaint. So there can be a hearing where the court decides that that person's share should also be included in this sale, as long as it's fair and reasonable. And here you have what those limitations are going to be. Now, if there's no purchases of everyone's interest by the other co-tenants, then the court can make a determination of whether or not there's going to be a partition in kind or a partition by allotment. And the court can order the partition by allotment unless they find, you remember this from the definitions, unless the court finds that there's manifest prejudice or injury to the group of co-tenants. Okay, so the court can look at the whole picture and determine, is that really fair to partition in kind or by allotment? Is that going to be fair to everyone as a group? Because it may not be, and we have all those, I think it's 12 factors that the court's going to look at. And another thing to mention here is that co-tenants can get together in a group and ask that their individual interests be aggregated or put together. So like if you have 4 people who each have a 1/10 share, if you put all of their interests together, then they're going to have a 2/5 share or 4/10, whichever way you look at it. Okay. Now, then the court may decide that it shouldn't be done by partition or allotment, but it should be done by sale. Now, interestingly, if no co-tenant requested partition by sale, then the court would dismiss the case altogether, okay, because there's nothing that can be done to achieve that fair partition of some kind. Now, if the court, there's also this section C, which gives an option to the court to require one or more of the co-tenants to pay one or more of the others an amount so that the allotment and the shares can be as even as possible. So that might be something that would happen in your case. It just all depends on how everything is calculated, what the value is, and really how many individual co-tenants or owners that you have. And as I mentioned, well, I said it was 12, it looks like it's 7 considerations for the court when considering, is there manifest prejudice or injury to the whole group of, really to co-tenants as a group, if there's going to be a partition in kind or by allotment. So here's the 7 things, and I think they're very fair. Can it practicably be divided among the co-tenants? co-tenants? Is there a way to do that? Because sometimes the way a piece of land is set up, there's just not a way to do that, particularly if there's a significant number of co-tenants. Would the partition in kind or by allotment apportion the property in a way that the aggregate fair market value of the parcels would be materially less than the value of the property as a whole? That's important, and I think that's fair, because depending on what the value is again and what the number of co-tenants is, it could be that the property as a whole could bring a lot of money, whereas if you divvy it up into little pieces for everybody, each piece is going to be a very insignificant amount, and therefore it's just not fair to everyone involved to do it that way, because you do want to get the most benefit as possible out of the property, of the ownership of the property. This is also, I think, a really fair consideration, and that is ownership of the property and really duration of ownership or possession of the property. So you may have someone who's been an owner for a really long time, and you may have some who are significant relatives, close relatives, and that might be a consideration. Also, if you have a sentimental attachment to the property, the court is going to take that into consideration. Whether it's because it's ancestral property, has some kind of special sentimental value to you as a co-tenant. So, for example, maybe you've been the one living there, or one of the people living there, or if no one is living there, maybe you've been tending to the land in some fashion. So any number of things could be evidence of that sentimental attachment. Number 5, the lawful use being made of the property by a co-tenant and whether or not they would be harmed. So if you've got someone who's been planting crops out there, and now it's going to be divided up so they can't plant those crops anymore, and that was their livelihood, that's going to be taken into consideration as to whether or not there's going to be manifest prejudice or injury. Number 6 is the degree to which anyone has paid part of the taxes, insurance, upkeep, any of the other expenses of maintaining that property. And I think that's fair and certainly important too, because if the property is in the condition, shape, value that it's in because you as a co-tenant have been tending to it in some fashion or paying the expenses to keep it in that all those family names, then you're protecting that property should be taken into consideration. And finally, number 7 is just a catch-all of any other relevant factor, because there could be a lot of factors that when you're putting together a piece of legislation like this, you can't account for every particular eventuality that could be important for the court to consider. So that just sort of leaves it to the discretion of the court, any other things that the court or the judge thinks are significant in that consideration. And Section B here, I think, is important to note because it says the court cannot just consider one of the factors only. They have to go through all the factors and weigh the totality of all of the factors based on the circumstances of this particular case that you're in. Okay, now if the court has ordered a sale of the heirs property, then it has to be on the open market. Unless the court decides that it could be by sealed bids or by an auction, as long as that would be more advantageous and in the best interest of the co-tenants as a group. So all of these fairness determinations have to be made along the way. And again, keep in mind, you have the right to participate in this decision making and to enter objections to what the court decides. So just keep that in mind. If you're a party to the action, you're a co-tenant, you may want to get your own lawyer and have the opportunity to make your objections. Now, if the court does order that open market sale, the parties can agree to who the real estate broker is going to be to do that. And then if they don't, then the court will consult with everyone and, or if they do, I guess, and appoint that broker and determine what a reasonable commission would be. Now, if there's not an agreement about that, and again, agreements can be so important in these situations before, during, and after a piece of heirs property litigation. But if they don't agree, then the court just appoints someone themselves. And usually, if this is with a master in equity or a special referee, they're very familiar with potential disinterested real estate brokers that can be appointed. And so the court will make that decision if the parties can't agree. So you might want to agree, because once the court does it, you can object, but that's probably what's done is done. And of course, again, the court will determine that reasonable commission. So all throughout this law, the parties are given some opportunities to agree on things. And of course, in any lawsuit, there's things that you can agree on that help move the lawsuit forward. But in this particular area of heirs property, it's important, I think, throughout the law and the process that is being followed to say, hey, the court's going to make this decision if you don't agree to it, but we give you that opportunity to agree to it. And then, as is typical when properties are going to be offered for sale at public auction, it has to be done in a commercially reasonable manner and at a price no lower than what the court has determined the value is. And then the court will determine what terms and conditions of the offering the property for sale are going to be. And that's something that they do with some regularity, so they know how to set that up. And then if the broker gets an offer, here's, there's a process for reporting that to the court, and there's some decision making with that. And then the sale can be completed if that's what the ultimate decision is. If there's something wrong with it, there's some part of the sale that comes up that co-tenant doesn't agree with, they have the right to make that objection, but it's the final decision of the court. Now, there's also this section here. If there's not a offer obtained by the broker, then the court can make a decision that we're just going to take the highest outstanding offer. If there's offers that are lower than the fair market value that the court has established, then the court can say, okay, that price is $1,000 less than the value we determined, but I will approve that offer. They can also just go back through the whole valuation process and then just offer the property for sale a second time. And so those are some of the options there. Now, you can also still have a sale by sealed bids or an auction. And if the court does that, then it's going to be done just by the typical way that courts usually do sealed bids and auctions, and that's covered in other places in the law. Now, if someone purchases that property and they are entitled to a share of the proceeds, so in other words, if one of the co-tenants that's in the action to begin with, they've got, say, a 10% share, and they can go ahead and purchase the property at the sale, and then they can get a credit for their 10% share of the property. So they don't have to pay themselves, in other words. They just pay the purchase price, and they get a credit for whatever their share of that price is. Okay, This section of the statute just goes over the report that the broker has to provide if there's an open market sale by a broker. And that broker has to file a report with the court about the offering, and note here that there's a 10-day time period. So the court will not later than 10 days after receiving that offer from as determined by the broker, then the court needs to go ahead and accept that offer in order that it will be the purchase that is made, allow the purchase, in other words. And you can see here 7 things that the broker has to provide to the court so the court can make that final decision. And this is just a final piece of the statute that just says how the construction of the article will be. And this, I think, is important because we now have this ability to use electronic signatures. And what this does is notify people who are utilizing this law for a partition action that there is some modification of what's allowed as far as electronic signatures. And so, in other words, there's electronic signatures, there's also electronic notices. And when it comes to heirs property in particular, electronic does not always work. Not everybody has the ability to provide an electronic signature or to receive an electronic notice. And that's why, for example, as we talked about in the beginning, when you the property's been determined to be heirs property and you have filed a partition action and you're serving it, there has to be a notice posted on the property because that may be a way that some of the co-tenants or potential heirs will get notified. And so one last point, I think, when it comes to those potential heirs, one of the things that we often have to do in a partition action or other actions that involve a determination of the title of real estate, we have to include unknown heirs. In other words, there may be people out there that have a share or an interest because they're an heir of someone and we just don't know that, or we don't know who they are, or we can't find them in any way. We think they might be out there. An example of that is in a partition action that I did on one occasion when we were given the testimony, and one of the parties was asked the question about, all the people who might have a share. It suddenly came up that this person had adopted a 3rd child, and that adopted child had not been included. And so we had to start that process all over again. So there may be people out there, and you are much better off to include them as an unknown heir, so that if they appear 5 years after this litigation is all over, then their interest has been taken care of in that unknown heirs process. So there's a defendant, basically, the lawsuit is known as all of the unknown heirs. And one of the things you do to protect those people is you have to appoint a guardian ad litem for them. And that's just someone who guards their interest and participates in the lawsuit for them to make sure that their interest is protected, and that if they are out there and can easily be found, then they are made a part of the lawsuit. Now, I want to remind everyone that if you signed up and registered for the live presentation of this episode of Level Up Law, you will be receiving an email within the next week to 10 days that will have our flowchart that I have created about this statute and the whole process that has to be gone through. And I think it can be helpful if you're in the middle of one of these kind of lawsuits to make sure that all the I's are dotted, the T's are crossed, all of those little time frames are followed and adhered to make sure that everyone is given a fair shake in the process. So especially if you are the plaintiff or the person who is filing the partition action, that flow chart will be very helpful to you and your lawyer. So that is, I think, the conclusion of going through the Clementa Pinckney Uniform Heirs Property Act in South Carolina. And I think you'll find it to be very helpful when it comes to heirs property and acknowledging the special particular facts that can surround a piece of property that is owned by multiple family members over a lengthy period of time, some of whom may be alive and some of whom may be dead. So thanks for joining me. You can see here on your screen all the information for getting in touch with South Carolina Legal Services. You can apply for our assistance in legal matters, and you can do it by phone or you can do it online on our website. So all of that information is here. And also, don't forget to stay connected through all of our other resources at sclegal.org, at lawhelp.org/sc. And then also, of course, on all of our social media, where we post a lot of information throughout the year that can be really helpful, but particularly all of our videos on YouTube. We have over 75 Level Up Law episodes on different legal topics that you can find there. So be sure and go to our YouTube channel and subscribe so you'll always, and sign up for the alert so you'll always get notified when we post another video. Well, that's the end of today's presentation. Thanks everybody for joining us today. And we look forward to you tuning in again next week on Tuesday at noon for another Level Up Law episode. Thanks for joining us. That concludes today's webinar.